Hello everyone. Today we're going to do an IRAC case analysis. This is a kind of analysis that you might find on a law school exam or writing a legal memo or on an NCA exam. So this is under the topic of constitutional law in Canada, and this is focused on the judicial independence unwritten principle. From the case Walter v. BC. And we're going to take a look at the issue as to whether the Attorney General of BC can unilaterally set the pay of the chairperson of the BC Review Board. Okay, so let's take a look at the facts of this case. The petitioner has been chairperson of the BC Review Board for more than 20 years. The petitioner in this case argues that the process through which the Attorney General sets his pay violates the unwritten constitutional principle of judicial independence set out in the preamble to the Constitution Act of 1867. He's also arguing that it's set out in Section 7 and 11 of the Charter. The petitioner continues to argue that financial security forms one of the institutional conditions of impartiality and is part of judicial independence. The petitioner argues that he should be afforded judicial independence and therefore financial security. And the petitioner argues that the chairperson of the review board's function is so important and has such impact that it should be considered the equivalent of being a judge and therefore getting the constitutional protection of judicial independence. Right before this hearing, the Attorney General approved the bump to $190,000, so he was starting at around $135,000. He found that provincial judges were making over $200,000, and so right before this case, it was increased to $190,000, which is what the maximum of the range payable to a chair, as determined as an administrative justice there. Okay, so the petition hearing, which had advanced administrative law issues, was contained only in relation to the constitutional issues, like I said before. Okay, so those are the facts of the case. It's a few rules are essential here. So the Supreme Court of Canada has held that the constitutional principle of judicial independence applies to justices of the peace. This is in the L case. The requirement that the judiciary have sufficient financial security is a necessary part of judicial independence, which means that the executive branch is not allowed to arbitrarily interfere with the setting of the judiciary's remuneration. This is from the Valente case. Administrative tribunals perform a variety of functions and may be seen as spanning the divide between the executive and judicial branches of government. This is Port Hotel case. This is basically a ruling against what the petitioner's pushing here. Okay. Some administrative tribunals are closer to the executive end of the spectrum. Their primary purpose is to develop or supervise the implementation of government policies. Such tribunals require little by way of procedural protections. Other tribunals, closer to being a judge, their primary purpose is to adjudicate disputes through a hearing, and in this case, those tribunals may possess court-like powers and procedures, and therefore would be more independent. This is from Newfoundland Telephone. Finally, many administrative tribunals grapple with charter rights or are tasked with making difficult decisions involving the vulnerable accused. For example, the Parole Board of Canada adjudicates over the liberty interest of inmates, but has not been found to be a court of competent jurisdiction for the purposes of granting charter remedies, and its members are not judicially independent. So this is from the Mooring case, and that is, again, a direct rule against what the petitioner is arguing here. So let's take a look at this judge's analysis in this case. In sum, the general law of contract would apply to the petitioner's pay by the Attorney General if it is found that judicial independence does not apply. It is undisputed that the unwritten source is in the preamble to the Constitutional Act of 1867, which says that Canada will have a similar constitution to the UK of that time. So this preamble is used to fill in gaps in the express, the specific terms of the constitutional scheme. And it is how the logic of the Constitution Act can be given the force of law. The Constitution, similar to the UK, means that the legal and institutional structure of constitutional democracy in Canada should be similar to that of the legal regime out of which the Canadian Constitution emerged. This is from Provincial Court Judges reference, also from that case. This does not suggest that the preamble can be interpreted in such a way to include administrative tribunals as being part of judicial independence, per the UK. And in Oceanport, the court stated clearly that the rationale of that previous case did not extend to administrative tribunals. The court separated, in that case, in Provincial Court Judges reference, administrative tribunals and judges, no matter how similar in adjudicative functions they were to courts. And even where the functions used to belong exclusively to the courts, administrative tribunals are part of the executive branch, and therefore the constitutional principle cannot apply to their positions. This judge agrees with the petitioner that the review board that he's sitting on is often dealing with difficult decisions and engages multiple charter-protected interests of the accused, and they're determining whether those accused should be discharged from custody or not. That's a lot of charter rights would apply there, and these are tasks of great magnitude, but the magnitude alone does not make the petitioner in the same position as a judge. And the chairperson position is relatively new, created for a specific purpose once a verdict has been reached at a criminal trial. So, given that this position is new, relatively new, and whereas some that were found in many cases justices of the peace and masters, longstanding tradition, those guys were given judicial independence. Provincial court judges is an example of a position with judicial independence as well, statutorily created and not based on a position in England. But the statutory scheme that this review board was created in has no historical origins in the United Kingdom. It's a diversionary stream within the criminal justice system, and it's designed for a unique purpose when members of a particular segment of society commit crimes. In conclusion, this judge does not find that the unwritten principle for judicial independence can be extended to this petitioner, and the charter arguments to the same issue were also found invalid, unable to stand alone as arguments, so not given much time here. So this judge says, given the above analysis and the fact that the Supreme Court of Canada affirmed Oceanport in a case called Bell, then for him to listen to the petition's arguments is asking him to overturn Oceanport. And the judge says, until this issue is again determined by Supreme Court of Canada, that Oceanport is the applicable law, and therefore the review board is not endowed with constitutional judicial independence, and the petition was dismissed. Click like, click subscribe, check out these other videos on constitutional law, and eventually even more Canadian law and NCA exam prep down here in the corner. And best of luck to you on your upcoming exams.